Freedom of residence. Articles 19(1)(e) and 19(5). According to Article 19(1)(e), every citizen of India has the right to reside and settle in any part of the territory of India. However, under Clause 5 of Article 19, reasonable restriction may be imposed on this right by law in the interest of the general public or for the protection of the interest of any scheduled tribe. The object of the clause is to remove internal barriers within India or any of its parts. The words, "the territory of India," as used in this article indicate freedom to reside anywhere and in any part of the state of India. It is to be noted that the right to reside and right to move freely throughout the country are complementary and often go together. Therefore, most of the cases considered under Article 19(1)(d) are relevant to Article 19(1)(e) also. This right is subject to reasonable restrictions imposed by law in the interest of general public or for the protection of the interests of any scheduled tribes. Thus, where a prostitute, under the Suppression of Immoral Traffic in Women and Girls Act, 1956, was ordered to remove herself from the limits of a busy city or the restriction was placed on her movement and residence, it was held to be a reasonable restriction. The freedom of movement and residence may be curtailed and suspended during an emergency. In the case of a foreigner, it can be restricted under the Foreigners Acts of 1964 and 1966. A foreigner may be ordered to remove himself from India. The important case on this point is Ibrahim Wazir vs. State of Bombay, AIR 1954, Section 7 of the Influx from Pakistan Control Act, 1946, empowered the central government to direct to removal from India of any person including an Indian citizen who had committed or against whom reasonable suspicion existed of having committed an offence under the Act, that is, to enter India without permit or valid passport. The appellant in the above case came to India without permit and was arrested and deported to Pakistan under the Instant Act. The court held the order of removal invalid on the ground that it imposed unreasonable restriction upon the fundamental right of a citizen to reside and settle in the country. The coming of a citizen to his homeland even without a permit not to be so grave an offence as to justify his expulsion from the country. In State of Madhya Pradesh vs. Bharat Singh, AIR 1967, Section 3(1) of the MP Public Security Act, 1959, empowered the state government to issue an order requiring a person to reside or remain in such a place as might be specified in the order or to ask him to leave the place and to go to another place selected by authorities in the interests of security of the state or public order. The Supreme Court held that Section 3(1)(b) of the Act imposes unreasonable restriction on the right guaranteed by Article 19(1)(b) and, therefore, void. The Act did not give an opportunity to the person concerned of being heard about the place where he was asked to reside. The place selected for him might have no residential accommodation and no means of livelihood, etc. The section did not indicate the extent of the place, area, or its distance from the residence of the person extended.